copies of what I was fixing to say. I didn't know whether to give them to you before or after I say it. I don't know. Everybody listens differently. Some of you read instead of listening if I give it to you.
You're looking right at me.
I'm so sorry. I surely do. Yes, ma'am. I want to start off by thanking the commissions for the special meeting that we had a couple of weeks ago. That was most gracious, and it was a great deal of effort and commitment on your part, and I know we're all very grateful that you allowed everyone to speak your mind. You commented that night that we'd stay all night if anybody wanted to, and it was a long night, and we were all very tired, but I do believe that the basic guideline of the commission is to lead and to serve, and I truly believe that all three of you are dedicated to that. And so I personally want to thank you for the effort that you put forth in this. The issue of the floodplain ordinance is very challenging to all of us. It's challenging our hearts and our values and our whole leadership. I think it was very right and correct the other evening that you allowed Mr. Sneed to go first and speak from the perspective of FEMA. I thought that was appropriate. I did disagree that the very next group that got to do the presentation were all the legal counsel for the various corporations, because that just meant it was 10 p.m. by the time any of us from the general public were able to start speaking. And by then we were all very tired, and I'm not sure how attentive we were to the issues that were being expressed. And Mr. Sneed had left, so he did not get to hear some of our comments, and he didn't get the opportunity to respond. I would like to state that my frustration all along has been with the process. I know Mr. Tennant was irritated with me. He was aware of the letter that I had written to each of the commissioners. I don't regret that letter. I stand by that letter. It was not an attack of Mr. Tennant personally. What I was trying to do was to attack the process. I have severe reservations about everything that was going on. Two of you sitting at this table, you as the former president and you as the current sitting president, on two different occasions requested that a committee be formed for the process of reviewing this ordinance. And those requests went into the minutes, and those requests were ignored. And the only explanation that I heard was that it brought forth the capability of special interests. But the other evening, Mr. Hastings from one of the oil companies took great pleasure in announcing to all of us that he had submitted numerous comments to Mr. Tennant and had had conversations with Mr. Tennant. And I'm unaware that Mr. Tennant had any conversations with members of this community, or that he took any phone calls. I don't even have proof that he looked at any of our comments. So I just have issues with the whole special interest thing. I still think the committee should have been formed. I saw some of the comments that were submitted by the local residents, and I saw the comments that were submitted by some of the representatives of the Watershed Association. I know the comments that I submitted. did not, the other evening, see any evidence that those comments had been considered or included. And I question whether you, as the body of the commission, were you guys ever able to view all of the public comments that were submitted? Did you get a chance to review them? Who actually went through those comments? Who decided what to read, what to ignore, what to include, and what to veto? Who was the person in charge of that? I don't know the answer to that. I have two main issues that I wanted to point out. The task before the county was to revise the current floodplain ordinance so that it would be compliant with Judge Sweeney's rulings. Judge Sweeney issued two orders, and I spelled them out in detail in your letter. The first regarded the West Virginia Code 58-3-1. And Judge Sweeney stated that the court had no jurisdiction to entertain an appeal under West Virginia Code 58-3-1. The basis of an appeal on the grounds of the establishment and regulation of a way is not supported by either law or facts. And he ordered that back in November. And it's recorded in our set of books. And I do commend everyone that code has now been removed from the current revised edition that's going to be presented here today. I think that is right and proper. The other order that came from Judge Sweeney, he stated in two paragraphs. One, he said the ordinance is constitutionally deficient. Later, he said the Doddridge County floodplain ordinance is in violation of the West Virginia Constitution to the extent that the ordinance fails to provide due process to surface and adjoining landowners potentially affected by a development. So the issue that was given to the commission from the judge was for us to revise the review process. At the last meeting in April, 2 weeks ago, the legal representatives had a lot of fun poking at me because of my choice of words. I used the word tweak, and they didn't like that. And that's their right. That's okay. I understand that. Weapons are, our words are the weapons that attorneys use. I do understand that. That's how they win or lose an argument. No disrespect intended. But you choose the right words and you get to manipulate the opinion. That's the way it works. I don't resent that tactic at all. I do resent the condescension, the tone that was behind those comments. I expected it from Mr. Hastings. I didn't expect it from Mr. Tennant. So I was surprised. To me, and this is my perspective, but to me, the legal world still remains a masculine society. That means in order to win, you've got to step on your competitors. And that's what we are. We're all lined up. We're on opposite sides, the game's in play, and we're competing for the floodplain. That's what this is all about. My point, again, was that all along it would have been very simple to form a committee. The floodplain administrator, a representative from the regional office of FEMA, a community member, maybe someone from the watershed association. The duties could have been divided up. Everybody could have worked together in order to get the revised sections in place. Then Mr. Tennant could have just reviewed it for the legal phrasing. It would have perhaps only taken a few weeks instead of 4 months. The decision was made to start all over from the beginning. That was a very daunting challenge to completely rewrite this entire ordinance. And again, I applaud the effort that was put forth and the time that's been invested. But I do think the process of doing this begins when we all admit what we do not know. And then when you ask for help, people step forward. And when that happens, it becomes plural instead of singular. We work together. The best ideas get to come forward, and maybe in the end, we all get a bigger piece of the pie than what we thought we were going to get. It's a compromise situation, but it works. To my understanding, it's a felony anytime you alter a floodplain without authorization. So, but somewhere along the line, the federal passed it down to the state, and the state passed it down to the county. So the bureaucracy has failed. The environment is not being protected. The West Virginia DEP has failed over and over to even show that it's a concern for them. The state legislature has done nothing to protect the rights of the surface owners. I'm not saying that the governor's office is showing an exhibition of any interest. The environment, as a result, is taking a beating. And I'm sorry, guys, but to me, the property owners are treated just like the bastard child who had the temerity to even show up at the family ball. That's the way I feel the surface owners are being treated around here. Everything has been passed down to the lowest rung of the ladder, and before you get insulted, the irony is, by doing that, that the ultimate power then has been given to the county commissioner. And this was my very first comment. I've made it over and over, and I've never seen it acknowledged or included. It's been ignored every time. The very top line on our floodplain ordinance, the first bold face of the next paragraph says authority and purpose. But the paragraph below that just addresses your intention, which is to be compliant with the NFIP program. There is nothing here which makes it very clear where you get the power. And there's nothing here which states where we get the authority to do this. And I have asked over and over that the paragraph be included which establishes the county's credibility. There are two executive orders, 110988, which was put, it's a federal executive order about the protection of the floodplains. The other executive order is 11990, or excuse me, 11990. 11988 is the establishment of floodplain management. Executive Order 11990 is the protection of the wetlands. One goes with the other. You cannot separate the floodplain from the wetlands. The purpose is to guide the decision-making process so as to achieve the wise use of the nation's floodplains. Wise use means reduced flood losses and protection of the natural resources and the function of the floodplains. That is a direct quote from the FEMA manuals. That is where the county gets its authority and its credibility. And I honestly believe that needs to be a part of this ordinance for when you get challenged. What those two executive orders mean, contrary to what some people think, it doesn't mean that development is not going to be allowed in the floodplain. It does not mean that. It means that the development will be severely scrutinized. And implies that there are perhaps some developments which should not be allowed in order to accomplish the goal. People multiply, population expands, our land does not. What we have is all we're going to have. And if we compromise our floodplains, we put everything at risk for the people of this county. Our fresh water is at risk, our livelihoods are at risk, our personal safety is at risk. The action may not take place next to my house, but that doesn't mean I'm not going to be affected. What she was talking about earlier today, Mariana, and Buckeye Creek, the effect is more than just the adjacent property. There were several times at the last meeting where the comments were made about the hay bales. The hay bales don't cause flooding, guys. That was just a statement that was intended for distraction. It's the massive construction which encompasses large acreage out of our floodplains. That's what causes flooding. When we introduce fill and paving materials and parking lots and large manufacturing plants, we increase flood damage. Just the paving materials and road beds hinder the ability of the ground to absorb the water anymore. So we increase flood damage. Now, I'm not talking about, I know there are a lot of temporary trailer parks that have recently been built. I don't have an issue with that. I'm assuming the word's temporary there. I'm also assuming that the owners of those lots are going to try to preserve the grassy terrain as much as possible instead of just paving it over with the parking lot. What I have an issue with are large-scale plants, drilling operations, parking lots, and warehouses. These things don't belong in our floodplain. When you take 6 to 7 acres out of a 10-acre floodplain, you have drastically impacted everything. Production companies with their deep shale multi-well pad drilling, they're taking up 6 to 7 acres easily out of the floodplain. And they're notorious, I'm sorry, but they are notorious for not wanting to remove the fluids from those waste pits. They want to fold the plastic liner over and they just want to bury it. But those liners leak eventually. The water gets in the aquifer, the grass dies, the trees maybe are damaged, pollution occurs. Shortcuts are taken and the end result is the damage cannot be undone. They'll claim that they're going to reseed everything and put it back in better condition. That's a misrepresentation. These large multi-well pads have to have 8, 10, 12, 16, and 24 tanks sitting out there. You have to have trucks. You've got to have roads to get the trucks into these tanks. These are permanent. So the ground is going to be impacted. Anytime that we do that, then the land can no longer absorb the flood water. And with all due respect to any representative that's here from an oil company, I apologize if they think I'm being out of line, but I just do not believe that certain construction should be allowed inside a floodplain. And obviously, I believe that the large multi-well pads have no business being in our floodplain. Where I come back with you is that FEMA grants the county the right to be restricted. They encourage you to go beyond their own standards. So, to my way of thinking, the county has nothing to lose. The ordinance has to be submitted to FEMA anyway, does it not? for review and acceptance. Doesn't have to go to FEMA once you're through with it. So let FEMA carry the burden. If they say we have to allow this type of floodplain development, well then it becomes their responsibility. Throw it right back at them. I've had several agencies, I contacted several agencies about our floodplain insurance, and they all told me the same thing, and Mr. Tennant confirmed it 2 weeks ago. We take out our policy, we pay our premiums, the development occurs, and the flooding happens. When they come in to assess the damage, if they determine that some of the damage to your home was caused by a man-made development, it was not an act of God or Mother Nature, then they don't pay. I don't care if you have the floodplain insurance, they're not going to pay. And Mr. Tennant confirmed it. So, if FEMA mandates that the county has to allow multi-well pad and massive development inside a floodplain, well, I don't see how they can any longer deny us compensation when the flooding happens. That's what I meant by throwing it back on their table. Let FEMA decide. If FEMA rules that you are within your boundaries to do this, and that weakens the case of the person that wants to challenge. There's more at risk here, in truth, other than just damage to our homes and our crops and our personal safety. There is also the issue of pollution to our stream and our water supplies. Anytime we alter the environment, we disrupt our natural resources and our wetlands. This county would not be the first. I know it feels like that because we're all, for the past year, we've just been like the deer caught in the spotlight, right? Everything's been focused on us. And there have been times that I've looked in the mirror and felt like I personally brought all this down on you guys. And I'm just wondering how did it all start. But Doddridge County would not be the first county to forbid this type of activity in the floodplain. Other counties are trying it and considering it. Other states are trying it and consider it. I do understand that everybody's watching Doddridge County. They're all trying to see what you're going to do so that they can either model it, copy it, or go the other direction. But sooner or later, the production companies are going to leave. And my question is, what are they going to leave behind? We have to live with what's left. It's my understanding today, and that's the reason I asked if I could speak first. It's my understanding today that the latest proposed revision is going to be submitted for a first reading. It's also my understanding that there will be no more changes. You will listen to our comments, but you're not going to vote or agree or deny any action on our comments. I did not receive a copy of the latest revision until 6 o'clock last night. I'd like to ask, when did the commissioners receive a copy of the current revised ordinance? So, have any of you, it took me 3 hours last night to read through this thing. Have you had a chance? Obviously, if you just got it this morning, you haven't read through it. You haven't had the opportunity to call Mr. Sneed or Mr. Wellings or Mr. Tennant or anybody and ask questions or to clarify any points. And so I think it's wrong to accept this revision today as a first reading. I called Mr. Tennant. He did agree, and he said he would be here on the 21st to address any issues that you have concerns with, to make any explanations of why certain things have been changed. There are things in this ordinance that have been changed. I don't know where those changes came from. Did they come from FEMA? Did they come from personal comments that have been submitted? They were not part of the original ordinance and now they are. Where did they come from? I think we have the right, you guys certainly have the right to know where those changes came from. I know we're all tired of this and we want it to all go away, but I don't think that you should be forced into accepting something today that you yourselves have not even had a chance to review. We've come this far. We can certainly go just 2 more weeks a little further. I ask you please to take advantage of this opportunity because some of these, next week when next time when Mr. Sneed comes, if you have questions and comments are made, I'm assuming if it's the first reading that you can vote on those comments right then and there to accept it or not, and it still retain its first reading. Am I wrong, Beth? I know once you submit something as a first reading, but if you all listen and vote right then and there, then I'm assuming it still remains a first reading. And then, therefore, you can vote the next time to make it final. This ordinance, as it is 45 pages long. I found 13 pages in here that have major flaws. So 1/3 of it, basically, has some issues. Mr. Foster stood up here 2 weeks ago and asked that the FEMA's interim technical bulletin be attached as part of this ordinance, because those are issues that apply directly towards oil and gas production. I did see one quote from that bulletin in this ordinance, but there were other items in that bulletin, and I don't see them anywhere in here. So I question why the bulletin is not adopted as part of the ordinance. There was an issue on page 29 where Mr. Sneed said the wording was wrong. The floodplain administrator may is wrong. He said that night that it had to be the floodplain administrator shall. That wasn't changed. It still says may. There's an item on page 36, and which one on page 36? I tried to ask this last time, and somebody explained to me if I'm reading it wrong, but at the bottom of page 36, it says a notice of, we're talking about that the notice of this permit application is going to go out. And it says, send to each property owner except the floodplain permit application location owner. Now, the implication here is that the person filling out the application is also the owner of the location. That's not necessarily true. If an oil and gas company is filling out an application for a permit, they don't necessarily own the location. But by this wording, what you're saying is, I'm not going to be notified because I own the land where the application location is, but I'm not going to be notified. That's the way this wording reads, if I'm interpreting it correctly. So I point out again that I think that's wrong. I guess I appreciate that you listened to me. I hope you consider what I'm trying to say. There's too much at stake here for us to just blindly accept and push forward. There are some good things in here, some really good things that have been added, and I applaud it. But there are still some issues that need to be addressed. And I ask you to take another 2 weeks until Mr. Sneed can be here. Thank you.
Thank you. We'll take a 10-minute recess.